Hello and welcome everyone to today's webinar, the criminalization of HIV non-disclosure and pause youth responses towards it. My name is Henry Wu. I am a research investigator with CBRC, the Community-Based Research Center for Gay Men's Health, and I'll be your moderator for today. To start, I ask that everyone be on mute during the presentation as there will be opportunities for questions afterwards. Feel free to enter questions into our chat box and our presenters will answer them at the end. Today's webinar is a continuation of CBRC's webinar series, which delves into topics and issues pertaining to our community of gay, bisexual, and other men who have sex with men and beyond. CBRC has a number of programs including the GB-MSM Health Network, the annual Gay Men's Health Summit, and the periodic Sex Now survey, which will be launching soon. For those of you who don't know, the GB-MSM Health Network is dedicated to connecting people and organizations in BC who are working to better the health of gay, bisexual, and other men who have sex with men, including trans and two-spirit men. I would like to thank PHSA, the Provincial Health Services Authority, for sponsoring this webinar series and making it possible for CBRC to continue to host knowledge exchange opportunities such as these ones. As well, I would like to thank YouthCo HIV Hep C Society, as well as the Canadian HIV AIDS Legal Network for partnering up with us today to make this discussion possible. I know some of you are here excited to hear from Neil Self of Positive Living BC. Unfortunately, due to an emergency, Neil is unable to join us today. However, we are very grateful to have Richard Elliott of the Canadian HIV AIDS Legal Network join us in Neil's absence and put together a presentation under such short notice. Richard, thank you very much. We really appreciate your time and support. I'll introduce Richard first and then hand it over to him. Afterwards, I will introduce William Flett, and he will be able to present on his youth-led project in response to HIV criminalization. After Neil and William present, after Richard and William present, there will be an opportunity to ask each of them questions, so I ask that you hold your questions until the end. As well, if you would like to send me a question, I will be moderating under the account Darren Ho. Without further ado, I would like to introduce Richard Elliott. So Richard Elliott is a lawyer and the executive director of the Canadian HIV AIDS Legal Network, www.aidslaw.ca, which is one of the founding organizations of the Canadian Coalition to Reform HIV Criminalization. Richard and the Legal Network have been working in various ways for more than 20 years to resist the unjust criminalization of HIV in Canada and globally. He was co-counsel for the Legal Network, Canadian AIDS Society, and the BC PWA Society, as Positive Living was known then, in their joint intervention in the case of R.V. Courier in 1998, the first case on HIV criminalization to come before the Supreme Court of Canada, and has been co-counsel in a number of subsequent cases before the Supreme Court in Canada and appellate courts in BC, Quebec, Manitoba, Ontario, and Nova Scotia on the issue of HIV criminalization. He has also testified as an expert witness at a trial in a BC case in 2010 in which the accused person living with HIV was acquitted. He holds an LLB and an LLM from Osgoode Hall Law School and was called to the bar in Ontario in 1997. So at this time, I would like to transfer the screen over to Richard. So Richard, if you can hear me, I'm just going to share the screen with you right now, and then 1 second. Okay, so before I do so, once I share the screen with you, Richard, if you go onto the WebEx screen, there should be a tab that says Quick Start. If you can click that tab, and then once you click that tab, there will be an icon that says Share Screen. If you click that, then people will be able to see your screen. So I'll be transferring it over to you now.
Hi, Darren. And you should see some slides that have come up on the screen. Thanks as well for the invitation to join you here today. As I understand it, what we're going to start off with is I'm going to give you a bit of an overview of the state of HIV criminalization in Canada, which is, of course, something that is still evolving. And then I believe there will be ample time for some questions and discussion afterward. So maybe I'll give you a quick overview of the criminal law in Canada and how it has been applied so far. And then when we come to the end of the presentation, we'll see some of the dimensions that are still in flux when it comes to HIV criminalization. So the first thing to understand in any discussion about HIV criminalization in Canada is that we are talking about the application of the federal criminal code. So we have one criminal code that is adopted by the federal parliament that defines what are crimes in Canadian law. But the administration of that law, which is adopted by the federal parliament, is actually the jurisdiction primarily of the provincial governments. So it is the provincial attorneys general and the crown prosecutors that report to provincial attorneys general that actually administer the criminal code. That is, that they prosecute cases under it for the most part. There are some exceptions to that. One such exception, which is important to note for the end of the presentation, is that in the territories, as opposed to the provinces, it is actually the federal attorney general, the federal government, federal crown prosecutors that are in charge of prosecuting offenses under the criminal code. It's also important to understand that the criminal code does not have any HIV-specific provision in it, or even a provision specifically about sexually transmitted infections generally. In the mid-1980s, the former provision that was in the criminal code called spreading of venereal disease was repealed, and that was largely because it had not been used much and because it was seen to be more a matter of public health rather than the criminal law. Now, that change happened as a part of a much broader set of revisions to many, many parts of the criminal law to modernize the criminal code to its current form, although obviously there have been any number of amendments to the criminal code since then. But it wasn't an HIV-specific decision. It wasn't a major part of the reforms to the criminal code. And so because that's the legal landscape that we're dealing with, the way that HIV criminalization has arisen, so that is the criminal prosecution of people living with HIV for either transmitting the virus or exposing someone to what is perceived to be a risk, a sufficiently serious risk of transmission without that other person's knowledge. That has happened not through charging people under an HIV-specific section in the criminal code, because there isn't one. Instead, it has arisen and evolved over time through the use of other general crimes that are defined in the criminal code. And you see on the screen here a list of some of the offenses that are set out in the criminal code that have been used with varying outcomes to prosecute people living with HIV in those different circumstances. They run the gamut from what are much less serious offenses in the sort of grand scheme of things, although of course any criminal charge is pretty serious, to some of the most serious offenses in the criminal code. You'll see at the bottom of the list that the offense of aggravated sexual assault is highlighted in red, and that's because the large majority of charges, especially in the last 20 years, have been charges for aggravated sexual assault. That has become the go-to offense, if you will, in the criminal code that prosecutors use in these circumstances, and I'll explain why that is and what it means for our ongoing advocacy to try to limit the unfair use of the criminal law. So specifically, in 1998, the Supreme Court of Canada, in a case called Courier that you see on the screen, that originated in BC, was the first time that the Supreme Court was called upon to address this issue. And this came after some of those other offenses that I've mentioned had been used in different provinces by different prosecutors in different cases with differing outcomes. So prosecutors had laid charges of all sorts, like the ones I showed on the screen before. Sometimes they had gotten convictions. Sometimes they had gotten guilty pleas. Sometimes they had gotten, it had resulted in an acquittal. And so there were conflicting decisions under these different offenses about whether they applied or not as a matter of law to deal with the circumstances that people were being prosecuted for. And so this case made its way up to the Supreme Court of Canada, specifically as an assault charge. Both of the courts below, so the BC Trial Court and then the BC Court of Appeal, had actually rejected the conviction of the person. They had agreed that there wasn't an offense of assault, a crime of assault, that had been made out by the prosecution. The Supreme Court overturned that and has set the basic legal framework in this decision that has applied since then. And the specific thing that you need to understand about this case is the reasoning as to why the Supreme Court said the prosecution could get a conviction and the test that they set out for doing that, because it has really shaped much of the advocacy since then. So when we're talking about prosecuting someone for an assault, we're talking about prosecuting someone for physically having contact with another person without that person's consent. And obviously that can range from the mildest, simplest kind of physical contact to something that we normally think of as an actual physical assault, but it's touching without consent. When that touching, that physical contact, happens without consent in sexual circumstances, it becomes the offense of sexual assault. So it's basically the same underlying definition of a physical contact without consent, but it's the added layer of it happening in a sexual context. And that is a distinct crime as opposed to just a plain old non-sexual assault under the criminal code, and it carries more serious penalties. So the question then, if someone is being charged with sexual assault, is whether or not the person with whom they were having sex, with whom they were having that physical contact, actually gave their consent to that contact. And the criminal code says that there is no valid consent to that contact in a number of circumstances. That includes where you obtain someone's consent through fraud. And so the court turned to this concept and said, okay, is there consent in this case where the accused person who knew he had HIV had sex with two women? He did not transmit HIV. They did have vaginal sex without a condom. And they said, well, is there retroactively something that invalidates what was clearly their consent at the time of the encounter to have sex? Is there a fraud here that meant their consent wasn't really validly given? And on the extreme end, you had prosecutors saying, you must always have to disclose the fact that you have HIV, and if you didn't disclose that fact to your sexual partner, then they did not give a valid consent because they were missing this piece of information. But the court did not go that far. They went far enough in our perspective and went too far, but they didn't go for that sort of blanket obligation to disclose. Instead, they turned to the concept of harm or risk of harm, and they said, if there is a significant risk of causing serious bodily harm by withholding information about a sexually transmitted infection, including HIV, then there is a duty to disclose that to your sexual partner. And if you don't disclose, then your partner has basically potentially been defrauded into having sex with you. The prosecution also has to prove, beyond a reasonable doubt, that your sexual partner would not have consented to have sex with you had they known that you have HIV, where there in fact was a duty to disclose that, i.e., in a case where there is a significant risk of serious bodily harm. And in 1998, the court concluded quite quickly that there is a significant risk of serious bodily harm, in this case, acquiring HIV, through, in that case, unprotected vaginal sex, so sex without a condom. And furthermore, they said the risk is such that it endangers the person's life if they were to acquire HIV. And so what that meant was that not only was there potentially a sexual assault, but the most serious degree of sexual assault could be made out. So there are 3 levels of assault or sexual assault. There's sort of your basic simple assault or sexual assault. There's a sexual assault that causes bodily harm. That's the intermediate level. And then there's an aggravated sexual assault, and that includes, under the terms of the criminal code, an assault that endangers the life of the person that is the subject of that assault. So this is the logic that the court followed to say, yes, you could get a conviction for an aggravated sexual assault if there is a significant risk of HIV transmission, and you don't disclose that fact. Fast forward 14 years later, and there have been a number of subsequent court decisions after that first case where courts had applied this test in different ways. The court in that earlier case also allowed, thanks partly or largely to the interventions by organizations like ours, that careful use of a condom might reduce the risk of transmission enough that there would be no significant risk of transmission, and therefore there would be no duty to disclose. And therefore, if you don't disclose, you haven't committed the offense of aggravated sexual assault. 14 years later, the Supreme Court revisited this in the other key case to be aware of, a case called Mabior, coming out of Manitoba, and unfortunately made the law worse, and a bit surprisingly, frankly, given what had happened since the earlier decision, and given some of the things that had been said in that earlier decision. What they said was the legal test of a significant risk of serious bodily harm is still valid. What we understand that to mean specifically in the context of HIV is that there is a realistic possibility of transmission, and that's the key phrase that you see highlighted on the screen here. If there is that realistic possibility of transmitting HIV, then there is a duty to disclose to your sexual partner, and if you don't, then you have potentially committed this offense of aggravated sexual assault. So the question then turned again on, well, how high does the risk have to be before it reaches this threshold of a realistic possibility of transmission? So much of the argument about what has been happening with HIV criminalization has been fought on where the line should be drawn about how much of a risk is too much and at what point could you face criminal prosecution if you don't disclose because there's too high of a risk. The one key thing that the Supreme Court said in this case that we can say with certainty is they accepted that if someone has used a condom for penetrative sex, they were talking specifically about vaginal sex, but this likely also applies in the case of anal sex, and that person has a low viral load, which they explicitly defined as meaning under 1,500 copies per milliliter, then the court was satisfied that there would be no realistic possibility of transmission. That is setting the bar very high, in our view, unreasonably high. And it was quite a disappointment, and a bit of a surprising disappointment, that the court set the bar this high. We had urged that merely using a condom alone should be enough, picking up on what the court had said 14 years earlier, or had suggested, although they didn't decide it definitively. We had also said, given the science that has since emerged, that if someone has an undetectable viral load, then there is no realistic or there's no significant risk of transmission, because that was the test that we were using at that time before they rendered this decision. And that in and of itself, having an undetectable viral load, should also in and of itself be sufficient to mean that you don't have to disclose and you're not a criminal if you don't disclose. The court did not accept those submissions. What they did say was what I've put on the screen here, that if you have both a condom and a low viral load, note that they went a little bit higher than an undetectable viral load, then there is no duty to disclose because there's no realistic possibility of transmission. So that then leaves some questions unanswered and still in the process of being answered and fought about in the courts. Will it ever be the case that courts will accept that a condom on its own or having a low or undetectable viral load will be sufficient on its own so that you don't have to disclose and you don't face risk of criminal prosecution? I'll come back to that question in a moment because there's a partial answer to that that is evolving and part of it that is not as encouraging. They also didn't address the question of oral sex, which we had asked them to say very clearly that oral sex does not pose enough of a risk to warrant criminal prosecution if you don't disclose. So what has happened from the time of the first cases until now. As of the end of 2016, so I apologize that these figures are slightly dated, there have been at least 200 cases in which people have been prosecuted. 184 people have been prosecuted in 200 cases. So obviously a few people have been prosecuted more than once. Most of those cases have been against men who have had sexual encounters with women, but there has been an increasing number, especially in the last 5 or 6 years, of gay men and other men who have sex with men who have been prosecuted for HIV non-disclosure. There's been a steady proportion, it's a minority, but it's been fairly steady, of prosecutions against women living with HIV, all in relationship to having male sexual partners. Within those women who have been prosecuted, and that's a minority, disproportionately Indigenous people, Indigenous women are represented amongst those prosecutions, and disproportionately women who have various kinds of socioeconomic marginalization in their lives. Among the men who have been prosecuted, it appears that black men have been disproportionately prosecuted, and certainly the media coverage of cases is disproportionate when it comes to a black man having been charged with one of these offenses. It is also worth noting that the prosecutions that we have seen have been almost exclusively for HIV non-disclosure. There has been a very small number, about 6 or 7 cases where someone with some other sexually transmitted infection has been prosecuted for not disclosing to a partner using the same legal reasoning about this being an assault because there was no consent. So there have been a few cases where hepatitis C, not usually thought of as a sexually transmitted infection, but sometimes occasionally can be, people have been prosecuted for that with mixed outcomes. And there have been some herpes prosecutions as well, and one, if I recall correctly, one case in which someone was prosecuted for not disclosing they had syphilis. You see here a representation over the years of the number of cases per year. And so the number has varied, but you see a sustained increase after 1998, which is the year of that first case that I mentioned. And that's not surprising because that was the case in which the Supreme Court of Canada clarified what could be the legal pathway for prosecutors to get convictions, whereas before they had been throwing these different offenses at the wall and seeing what sticks. After that decision in 1998, it was clear that this is the framework for getting a conviction for an aggravated sexual assault charge. And so it's not surprising that you would see the numbers go up after that. There have been some dips along the way. They also seem to have declined a little bit in the last few years, and we can talk about what the reasons for that might be, although they're a bit speculative at this point. For this audience, I thought you might be interested to see the breakdown among prosecutions, at least as of the end of 2016, showing the proportion of gay men who have been charged, or men who have been charged in relation to having sex with other men. And so you see it's basically a quarter of the men who have been prosecuted have been gay men or other men having sex with men. So what's happened in these cases? Most of the prosecutions, so just over 60%, have been ones where there is no actual transmission of the virus that is actually being alleged by the prosecution. It's merely for exposure to what is presented by the prosecution as being a realistic possibility or a significant risk of transmitting HIV. So remember, you don't need to actually show that the accused person infected someone else in order to get a conviction. The offense is, the crime is made out when there is exposure to that too high risk without disclosure. Majority of the cases have ended in conviction, and this is a substantially higher conviction rate than when you look at conviction rates for sexual assault charges generally. So what we normally think of as a sexual assault has a much lower conviction rate than the sexual assault charges that are based on allegations of not disclosing HIV status. And when you look at the sentencing, although it's always a bit tricky to compare sentencing because they're often so, they're very fact and case specific, which is what they need to be and should be. But overall, if you compare the sentencing outcomes in the HIV non-disclosure sexual assault cases versus other sexual assault cases, which is what we normally think of as sexual assault, the sentences that are imposed are harsher. So looking at that picture overall about who's getting charged, just almost exclusively people with HIV, what they're getting charged for, the conviction rate, the sentencing rate, who within the group of being charged, of people being charged, is being charged. From our point of view, it's clear that HIV stigma is operating here in the criminal justice system, as well as some other kinds of stigma and discrimination, including along the lines of race, for example. So there have been any number of things done to try to limit the scope of HIV criminalization to what we consider to be a more reasoned application, because in our view it's gone way beyond where it should be. And it's gone way beyond what a number of international recommendations have urged. Part of that effort has been, of course, to bring the science to bear in this discussion. Because, as you'll have seen from what I've presented, the two key cases, really the question of liability turns on the risk of transmission. Where do we draw the line? How much risks does there need to be before the law should require you to disclose and penalize you with a criminal charge and conviction if you don't? And so there's been an ongoing and building effort to try to bring the science to bear on the criminal justice system. And you see here on the list some of the interventions that have been really important in the recent years to that end. Some of them very deliberately, steps taken to try to specifically inform the criminal justice system. Others just important developments in the science that we have about risk of transmission associated with various acts, which then, of course, are useful in trying to get the criminal justice system and the actors within it to be more restrained in their use of the criminal law. And I flagged here a consensus statement that came from nearly 80 scientists here in Canada a number of years ago in 2014, specifically aimed at the criminal justice system because of the concern about the criminal justice system overreacting to very small per act risks of transmission and using one of the most serious offenses in the criminal code to deal with those scenarios. In a few months' time, this list should be added to by an international scientific consensus statement that will be coming from scientists around the globe, again, motivated very specifically about speaking to the criminal justice system and getting the criminal justice system to stop overreacting to what are, for individual acts, really small risks of transmission, and yet being treated as sufficient with just one single act as the basis for criminally convicting someone. So here is the Canadian Scientific Consensus Statement. You'll see that it addresses the per act possibility of transmission. So one act of anal sex under various circumstances, one act of vaginal sex, oral sex, etc. And you'll see that it describes the risks of transmission on a spectrum from low possibility, and that's the highest degree of possibility that they speak about as scientists per act, down to zero possibility of transmission. Now, obviously, as noted, this statement was adopted in 2014. It was groundbreaking at the time, and it remains, I think, one of the strongest statements on this to date. But of course, there have been some further important scientific developments since then that have only reaffirmed and, in some cases, strengthened the consensus that they articulated back in 2014 about just how low the per act risks of transmission are associated with various acts, for the purpose, I stress, of informing the criminal justice system, not for broader public health education messaging about what's higher risk versus lower risk, but specifically to say to the criminal justice system, this act under these circumstances is, carries a negligible risk of transmission or carries zero risk of transmission. And you see here on the screen how they've characterized the different activities under different circumstances. Of course, there has been since then the U equals U consensus that has emerged, and that is consistent with what scientists have been saying before, but has also now started to get more traction, at least a little bit, with some of the policymakers in this And the key thing, of course, from the U equals U, undetectable equals untransmittable consensus statement, I apologize for the typo on the screen there that I just noticed. The point is that if someone has a viral load suppressed below 200 copies per milliliter, then the risk of transmission is negligible to non-existent. So given these efforts to try to bring the science to bear on the criminal justice system, what has been happening? Well, the results are still mixed, and they're still coming in, and it's still the story is still being written about trying to limit the scope of the criminal. We have some conflicting approaches that have emerged. We have a couple of cases in the immediate aftermath of that most recent case called Mabior in 2012 that I mentioned, where basically a more conservative approach was taken, and the courts in that case, in Ontario specifically, which has been the province that has accounted for more than half of the prosecutions to date in Canada, they took a very narrow approach and said, we understand the Supreme Court to say you must have both condom use and a low viral load, which is not strictly speaking what the Supreme Court said, although they came close to saying that. But that's a very narrow and, in our view, incorrect interpretation, and it's an incorrect interpretation, I think, that a number of other courts have recognized is incorrect, and even the Federal Justice Department has also said is not the correct interpretation of that decision. So in those Ontario cases at first, basically they were saying, we don't care what your viral load is, because it's established here that you didn't use a condom and you had to have both a low viral load and a condom, there's still going to be a conviction. And prosecutors were still pushing for that in those years right after the Mabior decision in some places. However, we did see subsequently a much more reasonable interpretation and approach emerging in some cases in Ontario, but also in some other provinces, especially Nova Scotia. And so now we have at least 3/4 reported decisions where courts have been critical of that very conservative approach and have actually said we're going to allow an acquittal here, we're going to refuse a conviction because the person had a viral load that meant that there was no realistic possibility of transmission. The medical evidence in front of us here is that with this person's viral load, there was no realistic possibility of transmission, and that's good enough, even though no condom was used. So that's encouraging, but it is not yet firmly established and universally established across the country. So this is where we get to some of the current advocacy efforts and some recent shifts, and then I will wrap up. Last World AIDS Day, the Federal Department of Justice, Justice Canada, issued a report that had been a year in the making that has some very solid recommendations that are very much in line with the kind of more limited approach to the use of the criminal law that we have been urging for quite some time. And said things like, we don't think that people should be prosecuted when they use condoms, and that's sufficient. We don't think people should be prosecuted when there's a suppressed viral load, that's sufficient. We don't think oral sex carries enough of a risk to warrant prosecution. So this is all encouraging. Some of the arguments that we've been making are resonating there and getting picked up and getting some support. I stress, however, that that report is just a report from the Federal Justice Department. It doesn't change the law in and of itself. It doesn't necessarily change the practice of Crown prosecutors in and of itself, but it's a very important document to have out there and a very useful tool on which we can build further advocacy. And I believe that William is going to say something about that, and we can talk about it more in Q&A. What does start to change practice and law are three things. One, actual guidance documents or directives for prosecutors that say, in general, we don't prosecute in the following kinds of circumstances. And we have seen, finally, a shift in Ontario, a very, I stress, very modest shift, and one that is long overdue, last December as well. And Ontario finally announced that it would no longer prosecute people when they had a viral load under 200 copies per milliliter. Ontario has yet to say we won't prosecute people if they use condoms or if they just engage in oral sex. So those are two key outstanding things that they have yet to agree to. But we finally, after about 8 years of advocacy, got them to shift on the viral load question. And the Justice Canada report was an important piece of that. Just earlier this month, in a rather disappointing move that was completely non-transparent, the BC Prosecution Service adopted a new guidance, which is actually not even as good as the Ontario guidance, in my view, because it's not even clear about the fact that they won't prosecute people when they have a viral load under 200 copies per milliliter. It's a really fuzzy, wishy-washy new document from the BC Prosecution Service, and we really need to push hard to make it better so that prosecutors in BC will be more restrained in pursuing charges in future. It's also important to note that in BC, which is not the case in every province, there is what's called pre-charge screening. So before police lay a charge, especially in an area like this, they're supposed to actually consult with Crown prosecutors and get them to screen the proposed charge before they actually lay it. So another reason why getting good guidance for BC prosecutors could help head off some prosecutions before they even start. The other thing that affects the actual law on the ground is what courts do in their interpretations. And so I've already given you some examples of where some courts have started to adopt a more restrained approach, at least with respect to acquitting people who have a suppressed viral load. We still have to regain some of the ground that we had been previously winning on getting condoms to be recognized as sufficient. And then the third thing that can change the actual law that gets applied is to get Parliament to change the wording in the criminal code and narrow the scope of the offenses that can be laid and in what circumstances there's actually a viable charge to be laid by more narrowly defining the crime. So some of the key objectives then through these different means, whether it's through more arguments in the courts, whether it's getting better guidance or directives to prosecutors, and actually potentially getting legislative reform, which is a longer-term project, is to, for example, consolidate the fact that when people have a low viral load, they are not going to be prosecuted. There's no crime in that case. We need to reestablish the condom defense that we had been getting courts to accept until the second time the Supreme Court dealt with this and basically was quite dismissive of the protective value of condoms, unfortunately. And so that requires advocacy at the provincial level in various provinces. And at the federal level, because the Federal Department of Justice will likely develop some guidance for those federal prosecutors who, as I said at the beginning, prosecute charges in the 3 territories as opposed to in the provinces. Now, there have been very few cases in the territories. There's not that many people living with HIV in the territories. There have been 2 cases, I believe, in the north. But if we could get a very solid directive to federal prosecutors from the Federal Department of Justice that goes much further and is better than the Ontario and BC ones currently stand, then that would be a very helpful tool to have. It would help set the bar in a better place and support our advocacy at the provincial level. And we need to look at creative legislative amendments that could try to limit the scope of the criminal code offenses that are applicable. But that, of course, as people probably appreciate, is a much longer-term prospect. It's a much more difficult task, not to say that we're not calling for it, because the coalition is, but it's something that takes a lot more heavy lifting and also has some pros and cons to it. Whereas getting better prosecutorial guidance, we can probably only improve from where the situation has been, even though it's a tough slog even to get good prosecutorial guidance in some jurisdictions, as the Ontario and BC examples illustrate. So let me just skip over the last slide in the interest of time and direct you to a few selected resources. I understand the slides will be made available to you, so you don't need to write all of this down. But if you look at the Legal Network's website, the page specifically on HIV criminalization is aidslaw.ca/criminalization. And a couple of things you find there that may be of use to you and interest. There is a resource kit for lawyers and advocates, which has a bunch of interesting material in it. There are links to 2 films that are fully available for free online that you may wish to watch. There is also a resource kit for community service providers. So there's obviously a bit of overlap in the content, but there's actually some very distinct stuff as well. And the resource kit for people working at the community level includes, of course, material on the science and the law that I've talked about, but it also has some stuff specifically on practice issues about counseling with clients, what kind of records you keep or don't keep to avoid having evidence generated against your clients for use in a criminal prosecution, how to respond to media, and so on. And then finally, I'd invite you to look at the website of the Canadian Coalition to Reform HIV Criminalization, which you see on the screen here, including the community consensus statement on resisting unjust criminalization and the 3 calls to action that are in there from this countrywide coalition. The statement was issued last November, shortly before World AIDS Day, and is setting out 3 key areas for advocacy that are the subject of countrywide consensus through a multi-month process of community discussion, including calls for prosecutorial directives or guidance, as well as legislative reform at the federal level. Let me stop there, and if you have questions, of course, you can always call me or email me, and my contact information is on the screen. And thank you for the opportunity to present to you.
Awesome. So we would just like to say a huge thank you to Richard for filling in and for speaking on behalf of the Canadian HIV/AIDS Legal Network. And so again, thank you so much, Richard, for filling in really last minute. We were super lucky to have him today to present on our behalf. So at this time, I do want to address something, but before I do so, let me just bring the screen back up here.
Okay, so this will be a very, by the way, hello, my name is William Flett. As said, I work at YouthCo as a peer educator. Most of my programming involves coordinating pause youth programming. So in that, some of the positive youth that attend those programs are also volunteers, and those volunteers have overseen this and have approved all this content, and they are also on board of this content. So I will be super, in the interest of time, I will be going through it, in so much so that I'm basically skipping the first half, and even the big chunk of the middle, I will be quite quickly skimming. At the top here, you can see menti.com use the code 727227, and that is just information for you to view all of the content on these slides of notes. The beginning will just talk about some very brief facts about HIV transmission. Undetectable equals untransmissible, as well as some sort of general information about the HIV non-disclosure law. So this is right at the end of that. So as sort of mentioned in Richard's slides, there isn't very much evidence that this law is effective, and lawmakers defend this law is because it is a public health imperative. There isn't very much to that, and it doesn't this law doesn't make disclosing easier. Consent isn't validated because as it is said to fraud their consent. And in that, what consent needs to have is it needs to have the information that both parties can understand that this sexual act can result in the passing of HIV and that HIV can lead to AIDS. This is sort of a high barrier conversation and generally unwarranted. An easy way to, this is a bit out there. We'll look at it like this for a second. So this is a silence equals death poster, and it'll be a short excerpt from a poem by someone named Jordan Asenalt, if that's being pronounced correctly. It is part of a much bigger write-up on a Tumblr post, but basically this poem talks about, it details a sexual encounter where someone living with HIV sees a poster about the HIV/AIDS epidemic and believes that they are having sex with someone that is very understanding of stigma, and upon disclosing to them, the person does they spontaneously decide to change their mind for whatever reason, and that results in the person living with HIV feeling a lot of disdain and that this other person is feeling very hypocritical. So that's where the birth of the Silence Equals Sex poster came about, is because there is this sort of like feelings of this previous poster here. This poster was originated because this poster came about in a time where not talking about HIV was like endangering the life of the entire community of people that are either living with HIV or at risk of HIV. But now that isn't necessarily the case, and now that these non-disclosure laws are in place, it's sort of incentivizing not consenting, because not consenting is easier, and not consenting results in people still having sex, and that's generally what's happening. So yeah, the criminalization of HIV positive people perpetuates stigma and prevents prevention. HIV positive people are often caught in a catch-22 wherein disclosure is required by law, but often leads to immediate rejection. Form yourself, overcome stigma, and get laid. So talking back more about the non-disclosure law, I will be talking a little bit about the case law in regards to the definition for realistic possibility. Case law defines this a little bit differently than the fact sheet. I'll be skimming this a bit more. As said, it's based on penis and vagina sex, so it's unknown for other ways that we can have sex. It's pretty assumed that these laws also exist for penis and anus sex, but it's inherently unclear about oral sex, about other ways that we can have sex. And for that case, it's sort of generally not seen very many cases where this happens, but there have also been cases this case law was built on the premise that HIV non-disclosure has happened in situations that are completely unrelated to sex, whether it be spitting, coughing, etc. But as said in the law, we have a certain duty to disclose where there's a realistic possibility of transmission, and for this realistic possibility to be true, only one of these needs to be true. You can either not use a condom, or your viral load needs to be under 1,500 copies of milliliter per blood. This is some people can kind of understand where this number came from, but a lot of people think that this is a kind of a made-up number. Those of us that are charged, and because of all this, those of us are charged, the burden of proof lies on the dependent, so the person living with HIV. They must prove that they disclosed in a clear way, condoms were used, and that our viral load was under 1,500 copies per milliliter. This is not really realistic, so a lot of people see it as an undue burden, because it may be possible for you to prove that you disclosed in a clear way. So you have screenshots of a text message, or let's say it's somewhat possible for you to prove your viral load because you have medical documents saying that your viral load was so-and-so for the past 6 months. But it would be significantly more difficult that condoms were used. Even if condoms were saved and stored as frozen, the complainant can still claim that there was not condoms used consistently. So that's all about the case law. The fact sheet does complicate things a lot more. So the fact sheet from the Justice Department of Canada, released December 1st of last year, it outlined a bunch of changes, and most of the changes were around the definition of realistic possibility of transmission. Before, it was only one of those two things needed to be true. Now it categorizes risk into high, low, or negligible. A negligible risk is the criminal law should not apply if you have maintained a viral load under 200. This is much closer than to the actual viral load in BC that observes as under 40. So this is a more believable number, because there are some doctors that consider 200 to be undetectable around Canada, around US. So this is quite believable. So if you have this, the criminal law should not apply, so you will not be prosecuted if charged. The fact sheet details a low risk of transmission, you should generally not. So maybe you will, maybe you won't be charged if you're actively taking HIV treatment, use condoms, or engage in oral sex. This is sort of like a gray zone that's an improvement, but not necessarily great, because it still doesn't say if you can be charged, it can't be charged in any of these situations. If any of these situations are true, then you will count as someone that is generally not going to be charged. So it would be safe to say if you fulfill multiple of these, it will be more likely that you will not be charged, but that's still hard to say. And a high risk of if any of those are untrue, or if all of those are untrue. So if you have a higher viral load than 200, if you're not on HIV treatment, condoms are not used, and you have engaged in sexual activities other than oral sex. So this fact sheet may not affect charges in BC for a few reasons. One being only Ontario has announced that it will limit prosecutions for HIV non-disclosure. No reforms to the criminal code have yet been put in place, and the BC prosecutions branch are announced this March that it will not be updating the realistic possibility of HIV transmission definition. Their updates to it almost seem that they are much more closer to the old cases of the case law rather than the new suggested changes by the fact sheet. There are some very minute differences. So in undetectable equals untransmissible, it is going back and perhaps invalidating some of what I said perhaps, is that there is a third U to undetectable equals untransmissible, and that U equals U and unequal. So HIV disproportionately affects certain populations, notably Black and Indigenous populations, people who inject drugs, and people without housing. These populations are also disproportionately prosecuted, so it's unfair for them. Like, it's already well known that they are overrepresented in prosecutions and in prisons. So they are not necessarily it is not necessarily helpful for them to also be charged disproportionately more often. But also this law is also kind of about youth, because there's various stats here which talk about why it's like fundamentally difficult, and this is the result of like all in the end. AIDS Map USA 2015 says of all youth living with HIV, 7% achieved an undetectable viral load. So even under this new proposed changes by the fact sheet, only 7% of youth cannot be charged. So these new changes are still not great. So why should youth care about this law? The way this law is now written, it is not easily accessible information to youth. As said, this is like fundamentally high barrier information, and the way the law is written, it disproportionately discriminates against youth, and youth are more vulnerable to being charged based on the way this law is written. So because this law is about youth, using the values of MIPA, meaningful engagement of people living with HIV and AIDS, youth should be involved in discussions about how this law is changed or upheld. So what youth have done, as said, they have sort of been a part of making all this information, particularly PAUSE Youth have made updates to all of this information in regards to these recent changes. And yeah. And in volunteers that are like, if you're a PAUSE Youth volunteer, or if you know PAUSE Youth that are interested in volunteering, what we'll go doing forward, although changing the law is fundamentally something difficult, changing the law can be as simple as like talking about HIV and stigma, talking about undetectable equals untransmissible, and in these conversations, we will sort of like help break down stigma piece by piece, province-wide, Canada-wide, worldwide, slowly. And in this, we also have the opportunity at YouthCo for these PAUSE Youth volunteers to basically tell lawmakers what we think about what changes can happen. And one of the concerns is like in this, we are also trying to answer the question, how can HIV remain a public health focus if it is not criminalization at all? because this is something that will probably face as a barrier. So right before I open it up to Q&A with a few minutes left, unfortunately, I will have this question at the back of your mind as you are now open to ask us some questions.
Okay, so thank you, William, for presenting on the youth perspective there. So at this time, we would like to open up the conversation so that people can ask questions. I would just ask that if anyone has a question, if you could type it into the chat box down below instead of the Q&A box, that would be great. And then as well, if you could address the question to either Richard or William so that we can coordinate accordingly. I know that some of you are using your break times at work in order to attend today's webinar, so I thank you again for being here. And for those of you who do have to run off, we do understand if you need to leave. But again, so we'll open this time now for questions.
Is my screen still being shared?
Yeah.
Okay. I can't Q&A.
All right, so does anyone have a question?
Hi, Darren. Can you hear me?
Yeah, we can hear you now, Richard.
Hi. Yeah. So just thanks, William, for the presentation. Just one maybe point of clarification while people are formulating their questions. You talked about the Justice Canada report that came out on World AIDS Day last year, and you talked about the categorization of different levels of risk, so negligible risk, low risk, high risk. Two things to say about that I think it's important for people to understand. One, just because those things appear in the report from Justice Canada doesn't necessarily translate into a probability of whether someone will get charged or not in a given province. So just wanted to make sure that people didn't leave thinking that, well, if Justice Canada has described it in a report as this activity is negligible risk, then I probably won't get charged, but if they described it as high risk, I probably will. It doesn't translate quite so directly. It's really going to be a decision that gets made at the local level by the prosecutor that's got that case. They may have some regard to what's in the Justice Canada report, but it doesn't have any particularly binding or directive impact. It's just a paper basically out there from Justice Canada with some recommendations. The second thing is to just note that it is highly problematic from our perspective, and we have been saying this over and over again to Justice Canada and to the Public Health Agency of Canada, who put that material together for that section of the Justice Canada report, that what they are doing is describing per act risks of transmission using the risk categories from the CAS transmission guidelines that A, go back quite some years now, and B, are intended for public health messaging purposes in order to tell people that this activity is high risk, say anal sex without a condom if you have a detectable viral load, in comparison to this activity, say just oral sex or sex with a condom, that is low risk. They are relative terms that they are using in that document to say these things are higher risk and those things are lower risk. They are not intended to inform the criminal justice system, and the criminal justice system has to decide whether, based on one single incident of, penis X in hole Y, under certain circumstances, there should be a criminal prosecution for aggravated sexual assault because the risk is significant or poses a realistic possibility of transmission. So they are misapplying a public health education tool and the risk descriptors that are in that tool to a different system that operates for different purposes and is intended to determine guilt or innocence based on one act, not whether on a population level, for example, we know that doing this activity is higher risk than that activity. And that's a real problem for how those caste transmission guidelines are being used and applied by the Public Health Agency and have been reflected in the Justice Canada report. And we are trying to get them to actually back off misusing those categories in this criminalization context, because it's actually very damaging and harmful, because it continues to feed the idea that things that we know on a per act basis are really, really, really statistically small risk of transmission, but are characterized as still posing, say, a low risk of transmission or even a high risk of transmission for public health education purposes. That's not what the criminal justice system is about. And so we really need to be mindful in our advocacy to not let them continue to get away with that. End of sermon on that particular point.
Thank you, Richard. Are there any other? Okay. So I'm being prompted right now. We actually do have to wrap up. So just for some last-minute wrap-up points here, just letting everyone know that the webinar recording will be available online in the next couple of days, and you can check for it at cbrc.net. And I would also like to thank Richard and William again for presenting for the criminalization of HIV non-disclosure and positive responses towards it. So at this time, I'd like to just thank everyone for joining us today, and I hope that everyone has a great afternoon.